On January 2, 2018, Crystal Mangum filed a malicious prosecution complaint against Durham police officer Marianne and the Durham District Attorney's Office with the Durham County Superior Court Civil Division. Filing pro se with Dr. Hart's assistance, Ms. Mangum is the plaintiff in this legal action, which is civil, as opposed to being criminal. The defendants in Mangum's complaint are Officer Bond and the Durham District Attorney's Office. The online site of Ted A. Grieve and Associates most simply describes such a malicious prosecution claim as follows, quote, "Under North Carolina law, it is considered malicious prosecution to wrongfully initiate criminal proceedings against someone," unquote. Mangum's contention in filing the malicious prosecution complaint is that Officer Bond and the North Carolina state prosecutors wrongfully initiated the criminal proceedings of larceny of chose in action, a Class H felony, against her with its grand jury indictment on April 18, 2011. Online's LegalDictionary.net describes the 4 elements required to be proven for a successful claim of malicious prosecution. Similar in content to Grieve, but worded differently, the 4 elements are: 1. The defendant had no reasonable grounds or probable cause to file and pursue the original case. It must be proven that the defendant had no actual belief that the plaintiff was guilty or liable in the original case. Without any witness, both cashier's checks were transferred from Day to Mangum inside the apartment they shared. During an interview with Durham police officer the day following his surgery, Day told Officer Bond that he had given both cashier's checks to Crystal Mangum. This is precisely what Officer Bond documented in her police report of April 4, 2011. Additionally, there was no complaining witness for the larceny of chose in action charge. During the wee morning hours prior to the stabbing, Reginald Day asked Officer Curtis Knight about cash money being stolen from him by Mangum. Officer Knight told him that he would have to go to the police station and take out a warrant in order for the police to arrest her for theft. Day responded that he was going to not worry about it. In other words, he chose not to file any charge against her. There was no complaining witness, no eyewitness, no witness of any kind to support the charge of larceny of chose in action. Plain and simply, the larceny of chose in action charge against Mangum lacked probable cause or reasonable grounds to support it. The first element was met. The second element has to do with malice, there being 2 ways of establishing it. One is that the defendant filed the criminal complaint for a collateral purpose or an ulterior motive. As defined in LegalDictionary.net, quote, "The defendant filed or pursued the original case for an improper purpose, an abusive purpose, or simply out of malice or ill will," unquote. In Mangum's case, the reason for filing the larceny of chose in action charge was because it was a felony crime, which satisfied the felony murder rule to justify elevating the murder charge in Dave's death to first degree. Malice, for the purpose of fulfilling the second element, can be satisfied if it can be proven that the defendant made the criminal charge with full knowledge that it was false. In Mangum's case, Officer Marianne Bond knew from her interview with Reginald Day that he had given the 2 cashier's checks to Mangum, that she did not illegally take them from him. Furthermore, Bond had no witness, no evidence, and no proof to support the allegation that Crystal Mangum stole the cashier's checks from Day. The second element for malicious prosecution was satisfied following two different avenues. Element 3 requires that the defendant be an initiator or to have instituted the criminal complaint against the plaintiff, defined by lawdictionary.com as, quote, the defendant filed or played an active role in the original case. The defendant must have been responsible for bringing the original case, unquote. In Mangum's case, Officer Bond was the sole witness before the April 18, 2011 grand jury, her testimony under oath being responsible for the indictment on the larceny of Cho's inaction charge. The other defendant, Durham District Attorney's Office, presented the case before the grand jury, which handed up the indictment. Clearly, the third element was met. The fourth and final element requires that the plaintiff receives a favorable outcome regarding the charge, defined by legaldictionary.net as, quote, the original charge was terminated in favor of the plaintiff, who was the defendant in the original case. This case must have ended before a malicious prosecution suit can be filed, unquote. On November 22, 2013, the jury found Crystal Mangum not guilty on both counts of larceny of Cho's inaction.
State of North Carolina versus Crystal Mangum, file number 11 CRS 2608. We, the 12 members of the jury, unanimously find the defendant to be not guilty of larceny Cho's inaction, $400 cashier's check. State of North Carolina versus Crystal Mangum, file number 11 CRS 2609. We, the 12 members of the jury, unanimously find the defendant to be not guilty, larceny chosen in action, $300 cashier's check.
The fourth element was realized, thereby opening the door for Mangum to file a malicious prosecution charge against Officer Marianne Bond and the Durham District Attorney's Office. A statute of limitations is another legal issue relevant in Crystal Mangum's malicious prosecution complaint. LegalDictionary.net defines the legal entity as, quote, the maximum amount of time allowed for a party to initiate legal proceedings, whether filing criminal charges or a civil lawsuit. Statutes of limitation are set by federal and state law, and the length of time varies according to the nature of the civil or criminal complaint, unquote. The purpose of the statute of limitations is to ensure legal judicial process proceeds while evidence and witness testimony is fresh. It also helps ensure individuals are not blindsided by civil lawsuits many years after some issue or incident occurred. In North Carolina General Statutes, Chapter 1, Civil Procedures, Statute 1-52, provides a 3-year period by which to file a civil complaint, and in the malicious prosecution claim, the time begins to accrue from satisfaction of the fourth element, that is, the date the case made its favorable ruling. In Mangum's case, a favorable larceny verdict of November 22, 2013 began the 3-year period of the statute of limitations, which subsequently expired on November 22, 2016. The aforementioned legal lesson should help a layperson better understand Mangum's malicious prosecution complaint, its ramifications, and the defendant's response to it.
Funny
Mangum's friend and advocate, Dr. Haar, filed the malicious prosecution complaint on her behalf in the Durham County Courthouse on January 2, 2018. Over the ensuing months, Mangum and defendant officer Marianne Bond, represented by Durham Assistant City Attorney Kimberly Rayburg, and defendant Durham District Attorney's Office, represented by Catherine Shields from the Attorney General's Office, began exchanging briefs consisting of motions regarding summary judgments. On April 24, 2018, Governor Roy Cooper appointed District Court Judge Carolyn J. Thompson, an African-American female, to the Superior Court of the 9th Judicial District serving Vance, Warren, Granville, and Franklin counties. Her appointment was to replace Honorable Robert Hobgood, who was retiring at the end of the month. Late in the spring of 2018, the court calendar scheduled a courtroom hearing on motions submitted in Mangum's case to take place on August 15, 2018. The court calendar listed Judge Jim Harden as presiding in this case. 9 years prior, in September 2009, Special Superior Court Judge Jim Harden was appointed by Governor Bev Perdue to serve as a resident Superior Court judge for the 14B Judicial District covering Durham County. Since its filing in January 2018, Dr. Haar had been helping Mangum prepare for her case. Mangum, an inmate in state custody, having no access to a law library, internet, law books, or any other legal resources. With Haar's assistance by phone and through weekly visitation, Mangum accumulated written work product consisting of notes, legal strategy, rules and statutes, case law citations, and other information to help her with the presentation of her case and rebuttal of possible defense arguments. Sometime during the early summer months, weeks prior to the August 15, 2018 scheduled motions hearing, a judge switch took place. Instead of Mangum's case being assigned to Judge Harden, Cooper appointee Judge Carolyn J. Thompson was set to preside over the case. No explanation for the black rober change was given. Around noon, a couple of hours before the 2:30 p.m. start of the August 15, 2018 hearing, Crystal Mangum was preparing to board the inmate transport van to travel from the Neuse Correctional Institution in Goldsboro to Durham's County Courthouse when she was halted by a correctional officer. Mangum was told that she could not take any papers with her to the hearing. Mangum asked if the officer could transport them for her, whereupon she was instructed to return the papers to her dorm. Although the papers represented the work product that she had intended to use in her pro se presentation, she complied with the command and later boarded the van sans any work product documents en route to the Durham court. At approximately 2:15 p.m., defense attorneys Ms. Rayburg and Ms. Shields arrived together at court and leisurely began to prepare, removing items from their briefcases, arranging papers on their shared table, and setting up their laptops. Just prior to the 2:30 p.m. start of the proceeding, Haar requested of a bailiff to place 4 sets of manuals with exhibits on the plaintiff's table. Although Mangum had not yet arrived, Haar, a few Mangum supporters, and Crystal Mangum's mother were in the courtroom gallery. At 2:30 p.m., Judge Thompson called the court to order, with introductions given by defense attorneys. Mangum's absence forced a delay. About 5 minutes after the case had been called by Judge Thompson, Mangum was ushered to the plaintiff's table, her hands closely cuffed and her legs shackled. She was immediately addressed from the bench, not having time to make eye contact with her mother, whom she had not seen since her 2013 conviction, almost 5 years prior. Mangum began her presentation from memory, forced by lack of access to her work product. The thrust of her opening being based on merits, that the larceny of Cho's inaction charge lacked probable cause and should have been dismissed by the court prior to reaching the jury for deliberation. Then she requested time to look at the manuals on her table, manuals prepared by Har, which she had never seen before. The court granted her request. Mangum was wrestling to view pages of the document, obviously due to her hands being closely bound. Durham activist Victoria Peterson tried to call attention to this situation in hopes of having the manacles removed for the remainder of the proceeding. Thompson denied Peterson the opportunity to address the court, Mangum's hands remaining cuffed. Afterwards, Mangum elaborated on the fact that the larceny charge lacked probable cause. She then asked the court to allow a witness to take the stand under oath. Judge Thompson deferred to the defense attorneys. Rayberg demanded to know the identity of the witness, and upon learning it was Har, she objected. Bond's attorney, Rayberg, stated Har was censured by the state bar for unauthorized practice of law and offered a copy of the Wake County permanent injunction against him. She expressed her opinion that Har had been aiding Mangum legally in this instant case in violation of the injunction. Shields, on behalf of the Durham District Attorney's Office, objected to Har testifying as well. She stated that Har had been in Durham's clerk's office asking questions and filing documents on behalf of Mangum. Judge Thompson denied Mangum's request to present Har as a witness, but she did allow Mangum to present to the court and defense counsel the manuals Har had placed on her table. Upon noting that the manual had been prepared by Dr. Har, the judge dismissed it based upon an injunction that had been presented to the court by Attorney Rayberg. Finally, Mangum moved the court to 1. Have the 18-page document from medical examiner Dr. Clay Nichols' personnel folder, which Judge Ridgway deemed relevant, unsealed and released to her, and 2. To be released on her own recognizance.
Is there anything else you want the court to consider regarding the motions before the court today? Yes, I'd like to file a motion to have, because investigator Marianne Bond was the only witness to testify before the grand jury, and because I was found innocent of the larceny and chosen action, I would like to order for the 18-page report of Dr. Clay Nichols to be revealed. It was deemed relevant to my case on November 2012. My attorneys got a chance to see it. I've never had a chance to view it.
Judge Thompson did not respond to Mangum's motions and moved forward, at which time Dr. Har made an attempt to address the court regarding statements made about him by attorneys Rayberg and Shields. The judge denied Har's attempt and warned those in the gallery that anyone who is not an attorney representing a party in the case would not be allowed to speak and face removal from the court if not in compliance.
Not disrupting court. Thank you for your attention to these matters.
In arguing for her client, Officer Marianne Bond, Attorney Rayberg acknowledged that Bond had a lucid conversation with Reginald Day on April 4, 2011, the day following his emergency surgery. Rayberg also noted that Bond was a witness before the grand jury that indicted Mangum on murder and 2 counts of larceny of chosen action, but she did not challenge the merits of Mangum's complaint. Instead, Rayberg focused solely on the fact that Mangum's complaint had not been timely filed within 3 years of the favorable November 22, 2013 verdict. Shields, representing the Durham District Attorney's Office, defended her client by stating that it had not properly been served by the plaintiff pursuant to Rule J4C. Specifically, that although the Durham DA's office was the defendant, the summons and complaint should have been mailed to, delivered to, or served on the North Carolina Attorney General's office in Raleigh, because the Durham DA's office lacked a receiving agent. Shields joined Rayberg in presenting a timeliness defense and invoking a doctrine of sovereign immunity, claiming immunity without its waiver. Mangum, in her closing, noted that the defendant's arguments were based on technicalities, whereas her position was grounded in merits of the case, that all of the elements for malicious prosecution had been met. From memory, she countered the timeliness argument of defendants by citing Rule 152.9, which stated in cases of fraud or mistake, the accruing of the timeliness statute could be told from the time of its discovery. Mangum's argument was that during the 3-year statute of limitations period, she had been represented by legal counsel who, through fraud and or mistake, prevented her from timely filing her civil complaint. Ms. Rayberg, in her closing, noted that Bond did not modify, falsify, or hide her police report of April 4, 2011, claiming that her client did not commit fraud regarding the larceny of chosen action charge. In her final statement, Rayberg moved the court for a gatekeeper or pre-filing injunction against Crystal Mangum because of Haar's legal activities in which she falsely implicated Mangum. Rayberg's inaccurate statement was, quote, "I know that Duke University has had a number of issues with filings on Miss Mangum's behalf, and they have obtained injunctions from courts, from the federal court specifically, most recently in 2016, unquote. This statement is inaccurate on several counts. 1. Mangum never had civil action against Duke University. 2. Consequently, Haar never represented Mangum in a lawsuit against Duke University. 3. Haar did file a series of lawsuits against Duke University, but they had to do with a 2010 premeditated attempt to unlawfully arrest him because he was an African American and a Mike Nifong supporter. And 4. The gatekeeper filed in Greensboro's federal court was restricted to Haar's actions in his own case, which had nothing to do with Crystal Mangum or the 2006 Duke Lacrosse case. Attorney Rayberg had relied upon and been misled by a July 4, 2016 WRAL5 News online article titled, "Court Chastises Supporter of Duke Lacrosse Accuser." That libelous and defamatory article falsely stated Haar's lawsuit against Duke University was about the 2006 Duke Lacrosse case, there being no mention of the 2010 incident. Additionally, Crystal Mangum was not a party in the Duke Lacrosse case. Defense counsels did not argue the merits of Mangum's complaint, neither of them referencing North Carolina General Statute Rule 12b-6, which would have averred that plaintiff pro se Mangum failed to state a claim upon which relief could be granted. Judge Thompson denied Mangum's motion for default and summary judgment with prejudice. Thompson granted the defendant's motion to dismiss Mangum's complaint based on the following grounds. 1. Insufficient service of process. 2. Lack of personal jurisdiction. 3. Statute of limitation. And 4. Improper defendants were listed and served. There was no mention in the judge's courtroom ruling that Mangum failed to state a claim upon which relief could be granted. Judge Thompson also issued a pre-filing injunction against Mangum with respect to the District Attorney's Office or Durham Police Department because Mangum, quote, attempted to submit to the court's attention some exhibits involving a Sydney horror, unquote. Mangum's final words were, "I would like to appeal." The court taking note, the proceedings of the August 15, 2018 hearing were adjourned.